know we get an answer. That is the only reason I came here tonight. And I know you know in your heart of hearts that should be done. And you can do it tonight. If you could do it 2 weeks ago, if you could take them off 2 weeks ago, you can put them back tonight. Of that, I am confident. Thank you.
Any other comments or questions? Mr. Gray?
August 6th, all the members of this committee, I believe four of the members of this committee voted for Mr. Anderson. I think Mr. Anderson retained by us to advise us on legal matters. I don't understand a lot about law, but I think I do understand about the 2 points that he brought up about Mr. Felkner being able to resolve this matter very quickly, and Mr. Anderson's promise to help expedite the issue. And the second part, I think, is pretty much something I can understand is by allowing Mr. Felkner to sit here, will essentially have taken the situation out of the court issue. So I move that we support our solicitor, and that the chairperson rule the motion out of order and request that it be put on the next agenda.
I am going to do that. I am going to rule the motion out of order, and I am going to request that it be placed on the agenda at the appropriate time of the year. Because if we vote no, then what does it come up for reconsideration again and again? I think it would be well advised to think about it and have the time between now and then as far as the consideration of this, because I do think that it's murky, and we do have our legal counsel's advice, and that's where we stand. Yes, Ms. Carmen.
Just a couple questions. Point and then a couple questions. At our last meeting, this item was not on the agenda, yet we voted on it, and that was okay. Now, it is on the agenda to discuss Mr. Gorham's letter, and in Mr. Gorham's letter, he says, I hope we can resolve this. So this item is on the agenda this evening. So, under whatever advice we're given, just so I'm clear, it's okay to vote on an item that's not on the agenda, but it's not okay to vote on an item that is on the agenda. That defies logic. Having said that, I've got a big problem with all this because
just a minute.
That misstates the advice that I gave to the committee at the last meeting.
Wait,
it also misstates what I...
Were you addressing Mr. Anderson, Deb? Because you...
I was making a statement because that's in essence the advice that we were given at the last meeting. We were told that we pretty much had to vote on that item, whether or not he could serve, whether or not Mr. Felkner could serve on the committee. It is not within our purview. Nowhere in the Chariho Act are we granted the authority to remove a member of this committee. And if somebody doesn't like what I say tonight, am I going to be voted off at the next meeting? I think we're setting a precedent where we're removing our own members of the committee. Forget the fact that we're disenfranchising the voters of Hopkinton. Forget all the other issues that go along with it. We have already set a very bad precedent. Putting that aside, like I said, I've got a whole litany of problems with the whole way this is played out. I do take exception to your statement that the only ones that can resolve this are Mr. Felkner by taking this to court. If we had a concern, then we should have taken the issue to court. We should not have left it up to Mr. Felkner. But I do have one question. If this does go to court, is this covered under your retainer?
Absolutely not.
Or is this not going to be charged extra?
It is absolutely covered under my retainer.
Because I think that's where we're ending up, and perhaps we should have started there.
I'm glad that you pointed out. Yes, it is absolutely covered under my retainer. And I would appreciate it if it would go to court. With regard to the issue of whether there was an open meetings violation at the last meeting, let me make it very clear. The open meetings law has an exception. It has an exception when someone is disrupting a meeting. There was a disruption at the last meeting when someone sat in Ms. Serra's chair, when they were asked to leave, refused to leave, and most importantly, when we went into executive session, would not leave, and as a result, the school committee could not hold an executive session. That is codified in the open meetings law as an exception. As a matter of fact, you people bent over backwards at the last meeting because the Attorney General has opined that the chair and the chair alone could have ruled on that issue, but since the chair wanted a consensus of this committee, he put it to a vote. So the only mistake that was done here was, frankly, the chair gave more due process than was required under the law. Second of all, the statement has been made repeatedly tonight that this committee has no authority to do it. And I have brought your attention to the case of Bailey versus Burns. With regard to Mr. Bailey, the issue was not that Mr. Bailey had been convicted of a felony. It was that he was ineligible to serve because he was convicted by a felony. The issue is eligibility. If, for example, one of you folks who lives in Hopkinton moved out of Hopkinton and moved to Pawtucket, this committee would have to deal with the fact that you are no longer a qualified elector and therefore cannot serve on this committee. Somebody has to make that decision. The law puts that decision in this body. Last but not least, it's been said tonight, oh, it's not written down anywhere. You don't have the authority to do it. Ladies and gentlemen, the United States Supreme Court in about 1964 went back and looked at all the history of the clause that Mrs. Carney cited tonight and looked at all the antecedents of it. And the question was asked tonight, did we go back as far as the Magna Carta and so forth? The Supreme Court didn't go quite back as far as the Magna Carta, but they did go back into colonial history. And they looked at what the colonies did. Did the colonies decide that a board could exclude one of its members, not because they disagreed with his views? This has nothing to do with anyone's views. It is a question of eligibility. And the United States Supreme Court cited a case from Rhode Island from 1683, wherein the legislature, and this was long before there were constitutions and anything like this, where the Rhode Island legislature said, and I don't know what you exactly called the legislature back then, whether you called it the General Assembly or not, said that a gentleman from Warwick was no longer eligible to serve. And the legislature voted that gentleman out of the assembly, whatever you called it back then, because he was no longer eligible. This is a question about eligibility. It doesn't have to do with whether somebody committed a felony. It has to do with eligibility. You become ineligible if you move out of town. You become ineligible if you commit a felony. And under the Hopkinton Town Charter, you become ineligible if you assume another elective office. That is the issue. With regard to resolving this in front of a court, again, as I have indicated, Mr. Felkner has to bring the case. Mr. Felkner could bring this case. Madam Chairman, I am requesting that I be allowed to ask Mr. Gorham if Mr. Felkner will bring the case so that I can understand that I need to be here through the next month so that this can get resolved.
You want to ask me?
I'm trying to ask the chair. May I,
You're asking me a loaded question, but I'll answer it.
If
You could have been...
prudent, then
Sure.
if the question is asked, you
Madam-
may approach the podium and please respond.
Sure.
I'm still ruling motion out of order. We're having discussion. So hopefully we'll wrap this up.
I
because
apologize, Madam
we're not
Chairman.
the court, and I just have to
I
run a
know.
meeting here,
That's-
okay?
I
So,
know you're not in
I would
court. That's
appreciate
why
it
we're
if-
here. We're here because we don't believe that you're in court. But to answer Mr. Anderson's question, if Mr. Felkner, I said it's inevitable, we're going to court on this to get this resolved. I tried to be as eloquent as I could.
So-
But to answer the question directly, I don't think he has any choice. Of course he has to vindicate the post that he was elected to. He has to indulge a court. The people of Hopkinton knew that he was a member of the school committee when they elected him to the council. So he now must, because you've had him escorted out by the police at the last meeting, he has to go and ask a court to intervene. He has no option. Because he respects the rule of, he